Hello, everyone. So, um, it has been quite a few weeks, actually, shall we say, with the unsealings. It's been so much. Um, I really needed to take a minute after after Dr. Jennifer Freyd's expert witness report. That was just mind blowing. But in all seriousness, my little girl's not been too well either, so I've had a couple of days away. If people who've been following me long enough will know that I don't just cover the main Lively v Wayfarer case. I do actually cover the surrounding side cases, the related cases. And as many people will know, Brian Freedman and his law firm are being sued by the widower of Travis Flores. Now, Brian Freedman, why do I say this is related? It's not in one sense, but it is in another. So Brian Freedman represented Travis Flores back in 2020, 2021 against Justin Baldoni and Wayfarer. So that's where there is a relationship. Obviously now Freedman is representing Justin Baldoni against Lively. They are completely different cases in that sense that they are unrelated. They do not have the same issues, the same causes of action. But they have been linked, and it's because of the reference. Travis Flores' estate has decided to sue Freedman. So I have covered this. I've covered the complaint in a video, and then I followed that up then with the response, which was a motion to strike and an anti-slap. At the end of the video, I did comment on this document. So what this is this is a section 170.6. Basically, this is to seek the dismissal of the judge. So Freedman's attorneys have filed this at the same time as filing the motion. And what this is a declaration, and what it says is, I'm a party or attorney for a party to this action or special proceeding. The judicial officer named above, and they've cited Judge Proc Hammond, who is the assigned judge, before whom the trial of or hearing in this case is pending, or to whom it has been assigned, is prejudice against the party or his or her attorney, or in the interest of the party or his or her attorney, so that declarant cannot or believes that he or she cannot have a fair and impartial trial or hearing before the judicial officer. Now, this is dated January the 5th, so that's the same day as the motion to strike. There is no reason here for this. They've not had to file anything more. And I wanted to go back over it really and just look into it a little bit deeper, I think, because I find this interesting. This is not something we've had in any of the other cases, the Lively or related cases. So I wanted to have a little look further into it. So, okay. What is California Code of Civil Procedure? Well, it's a peremptory challenge under California Code of Civil Procedure, section 170.6. This allows any party basically to remove a judge once without having to prove any actual bias. So there is no need for them to say, well, these are the reasons and here's the evidence for our belief. They get one shot where they can file this declaration and remove the judge. But they have got to declare under penalty of perjury that they do believe the judge is biased against them or their attorney. Okay, so they can't just it's not something you can just, throw out there with for no good reason. There has to be good faith involved. Okay. So, what this does then, right, is it forces the court basically to immediately reassign the case to a different judge. The challenge judge cannot rule on the merits of the case once the challenge is filed. And it's often seen as a strategic move, which is used when a party believes that a judge may be unfavorable based on prior rulings, reputation, or courtroom dynamics. Now, what it doesn't do is accuse the judge of misconduct. It doesn't require any evidence of bias, and it doesn't reflect on the merits of the case itself. Okay. So, no proof is required. They just need to, so the party just needs to declare a good faith belief that they cannot receive a fair trial, and no evidence of actual bias is necessary. There's a formal process, so the motion can be oral or written, but it's got to be supported by an affidavit or sworn statement affirming the belief of prejudice. And that is basically what Freedman did file with this. Was if we go back to this document, at the bottom, we've got the signed declaration, which is, I declare under penalty of perjury under the laws of the state of California that the information entered on this form is true and correct. And then there are strict timing rules. So this must be filed before trial commences or hearing begins. Typically, this is within 10 to 15 days of judge assignment or appearance of a party. So the judge was actually assigned on the 8th of October, but Freedman's side, they filed for an automatic 30-day extension on top of the normal 30 days that they get to respond. And then their filing of the motion to strike is them effectively appearing. So they have filed this at the same time. So they should have, adhered to that request. I'm not I'm no expert by any stretch on California law, but that's how I've interpreted it. If anyone else who I might speak to Omar actually, if anyone else can weigh in who has knowledge of California law, that would be really great. But that's just how I've interpreted it. Okay, so what happens? Well, the judge reviews. The motion is, so he reviews the case. The motion is filed. The judge then steps down and a new judge is assigned. So there are some key safeguards to this. The judge must step down immediately if motion is timely and properly filed. Only one peremptory challenge is allowed per party per case. So if the estate of Travis Flores wanted to file one at this point, because they appeared on the 8th of October, and the judge was assigned on the same day, so they would have been aware of that as the plaintiff, so they would have had more notice, so they would be outside of the time limits now. This process is designed to protect fairness whilst maintaining public confidence in the judiciary. And also, it balances access to impartial justice with respect to judicial resources. So, Freedman. We all know and love Freedman by this point. I feel like this is a slide I probably didn't need to put in here, but I'm going to anyway because it's interesting. You'll see why. So I've had a look into this. Now, Freedman, there are no cases that I can find where Freedman or his law firm have gone in front of this judge. So there's no links. I also couldn't find any links, professional, personal, or financial, to this judge against Clement Suri, who is also an attorney, or Travis Flores. So, what could be the issue? Why would Freedman potentially file this? And then you have to look at the judge's kind of background, I guess. But we'll start with Freedman's. Well, what's his style? Okay. So Freedman, as we all know, is an entertainment attorney. I don't think it's unfair for me to say that he's he's got a reputation for being quite a performative attorney as well. You know, he does defend his clients quite aggressively and quite publicly as well. And that is why he is such a successful entertainment attorney specifically, because you know, the celebrity world, and we're seeing it with in the Lively case specifically, reputation is everything. It is. If you can protect the reputation, it's almost like nothing else matters. And Freedman, specifically with Justin Baldoni, you know, he's now in a bit of hot water potentially with some of his statements that he's made in defense of Justin Baldoni. But I think it would be unfair to not credit him with bringing the public support back to Justin Baldoni for the way that he approached the case, you know, in the early stages, because of the statements he made, because of the way he brought in evidence. You know, he probably knew that the Exhibit A, the timeline, would end up either being stricken or disregarded. It didn't matter. He put it out there. And once it's out there, you know, much like all the text messages that went into the New York Times, you can't get it back. So, and that was what really pushed the public towards supporting Justin Baldoni. You know, and there's been other statements too, you know, which have kind of, I think us content creators who follow this case, who kind of support Wayfarer, very much love Brian Freedman for the way he handles things and his approach. But not all judges like that. Freedman, he does like to, he's known for, you know, trying to achieve early dismissal in his cases, aggressive anti-slap positioning, narrow pleadings. And when I had to look through the background of Brian Freedman and compared that to the background of Judge Proc Hammond, I felt it would have been a huge mismatch. Sorry, tired now. But yeah, so that is why I think that this move is actually going to be strategic, because you know, and you can see that already, because the first thing they've done is to file a motion to strike the complaint, so that would be an early dismissal. It's also an anti-slap motion, and Judge Hammond is quite cautious. He's known for being cautious with early dismissal. Sorry, I'm just trying to move through some of these slides. Right. So, I mean, there is a possibility that there is alleged prejudice, but I just can't find anything at all. When I've looked into it, I can't find any conflict of interest, or anything that would specifically point to, you know, oh, that's why he believes there's bias there. I can't find it. So let's have a look. Judge Hammond. Okay. So demurrers. We'll start there, I think. Yeah, we'll start there. So demurrer. So that's a legal pleading that challenges the sufficiency of another party's pleading. And what it basically does is it asserts that even if the facts are true, they don't actually constitute a valid legal claim. And Hammond's history on that, he tends to sustain demurrers with leave to amend or overrule demurrers when the complaint is factually detailed. He does like to avoid, if he can, terminating a case at the pleading stage unless the defect is obvious, which is a plaintiff-friendly tendency. And this obviously for someone like Freedman, who usually relies on kind of the early knockout motions, anti-slap leverage, aggressive pleading challenges, he's not the ideal judge, basically. And then when we go to anti-slap motions, Hammond is not known as a reflexively pro-slap judge. His pattern is to allow discovery if factual disputes exist, deny slap motions when the speech is intertwined with alleged professional duties, and require a clear public interest nexus. So in a case which involves things like alleged privacy breaches or malpractice, alleged defamatory statements about a deceased client, this could make an anti-slap win hard to achieve. So Freedman's team would absolutely want a judge with a stronger track record of granting slap motions. And by having Judge Hammond removed, they could have one that is more sympathetic to their motions assigned. Then we got his record on summary judgment as well. So, and again, this is not set in stone. This is not, this is how he is in every situation or in every case. But kind of his tendency seemed to lean to, for motion for summary judgment, he requires a clean evidentiary record. He does not like fact-light motions. And he denies motions for summary judgments when credibility issues are central. Now, remembering that this case involves malpractice allegations and privacy claims, and those two in particular almost always involve credibility disputes. So again, the style of this judge would not really go in favor of the defendants in this case, which would be Freedman and his firm. When it comes to discovery, Hammond also, so he has a reputation for allowing quite broad discovery. He likes his privilege logs to be very detailed. Now, that's not necessarily a bad thing, but someone like with Freedman's style may not want that particularly. Protective orders, they must be justified, not assumed. And he pushes parties to exchange information early. In cases like this, where the defense may want to shield things like internal communications, client handling notes, reputationally sensitive material, this is strategically a problem. And then finally, we have the courtroom culture side of things. So Hammond is known for quite strict deadlines and no tolerance for gamesmanship, which is a problem for Freedman specifically. Not so much the deadlines, I guess, but certainly, as I said, Freedman can be performative, and that he does use that a lot, and it does often, achieve success for him. You've got a judge here who won't put up with that. Quite similar to Lyman, actually, and it does appear that, Lyman has successfully clipped Freedman's wings, which is why we hardly see filings from him, or we he doesn't speak as often when there are hearings, because you can hear the kind of you can hear in Freedman's tone and the way he speaks you can hear in Lyman's tone and the way he speaks to Freedman that Lyman is kind of over his tactics. And again, there's nothing wrong with Freedman's tactics. They are successful and they get a job done. They're strategic. And they are far less, in my opinion, immoral, unethical than tactics like Van Zandt. But Judge Lyman does not like him. And it sounds like Judge Hammond is, of a similar kind of mentality. He also doesn't like, so Judge Hammond also doesn't like, arguments that are kind of non-performative. He expects concise arguments. Freedman's style is, again, it's aggressive. It's quite theatrical when it's needed. It's strategic in timing, and it's quite motion heavy. So this is kind of my thought process as to why Freedman has filed this. But again, I don't know for certain. I just cannot find anything quite, specific that will tell me, well, this is the reason. And a lot of that is because they don't need to provide the reason. So if this motion was granted, Judge Hammond would be immediately disqualified and replaced by another judge, ensuring a fresh judicial perspective. This would then ensure that, I don't know why I put client there, but it would ensure that Freedman, who is the client, receives a fair trial before an impartial judge, potentially, which would reinforce judicial integrity and constitutional rights. So there is some strategic deployment of Section 170.6 in high-profile or contentious cases where perceived bias threatens fair outcomes. Now, again, as just to go back and reiterate, because this is important, timing is important. Motions must be timely filed. Typically, within 10 to 15 days of learning the judge's identity or the party appearing, late filings are automatically rejected. So I think the deadline is 15 days, right? So for the plaintiff, that would be 15 days from the notice of assignment, because they will have filed their complaint. The defendant has time to respond to that complaint. So I'm fairly sure that the 15 days for them begins after the first appearance, which would be when they file their first motion response. Interestingly, though, in criminal cases, there is 30 days after the first appearance, because you can actually do this in criminal cases too. It's under a different law, but yeah. So again, and as we said, no proof is required, but good faith is essential. So you cannot just file it without having a good kind of good faith basis for doing so. So there is a balancing act. The statute balances parties' fundamental rights to fair trials with judicial efficiency and respect for the integrity of sitting judges. Okay, so we come to the conclusion, the power and purpose. So California Code of Civil Procedure, Section 170.6, serves as a critical safeguard in civil litigation, empowering parties to prevent judicial bias and ensuring the integrity of the trial process. Freedman's motion against Judge Hammond exemplifies the strategic use of this powerful legal tool to protect fair trial rights in high-stakes litigation. Understanding Section 170.6 empowers litigants, attorneys, and the public to ensure justice is served impartially and fairly in California civil courts. And obviously, when we look at everything all together about both Freedman and Hammond, I believe that the defendants probably saw Hammond as not pro-defense on early motions, not pro-slap, overly broad on discovery, procedurally strict, not entertainment law fluent, and not deferential to high-profile litigators. For a defendant, as is the case in this lawsuit, who is facing malpractice claims, privacy claims, defamation claims, reputational risk, potential discovery into sensitive communications, I would say that this is exactly the judge that you would not want. And that is why I think that this has been filed. I think it's strategic. I will keep everyone updated then, just like if it's been, if it's been agreed or not, because this can be refused. But we will have to, at the moment, there has been no decision made on it. All right, so I just thought that'd be interesting to kind of have a look at and go over. All right. Thanks, guys.